Okay, council, once again, welcome to an oral argument session for the 5th District Court of Appeal. We have one case on the docket here at 1 o'clock, and I want to introduce the other members of the panel before we begin. My name is Rand Wallace. I'll be presiding over this proceeding. We also have joining us Judge Eric Eisnagel from Seminole County and Judge Dan Traver from Orange County. I do note that we have two attorneys that are appearing for the appellant in this case, and I believe Mr. Russell and Mr. Brady both want to argue. Is that correct?
Yes, Your Honor.
Yes, Your Honor, that's correct.
Okay. Well, you've got 20 minutes, and I will not in any way try and control that 20 minutes. I'll just ask for you all to control that. I'm going to assume you want 5 minutes for rebuttal unless you advise me otherwise. And then Mr. Glassman for the City of Daytona Beach. So it's Mary Sink et al. Versus the City of Daytona Beach. And Mr. Russell and or Mr. Brady, you may proceed.
May it please the court, I'm Keith Brady, appearing along with David M. Russell for the appellants. I'll present a brief overview, address any questions, then yield to Mr. Russell. The city's ordinance is preempted by the state law, and no exception applies. That's our case. To summarize, there's a state preemption against any law or ordinance that prohibits vacation rentals, and there's an exception. The exception is for a law or ordinance that was passed on or before June 1st, 2011. So you have a preemption and you have an exception, singular exception. Yet in 2015, the city passed an ordinance, and in that ordinance, they did in fact create a new prohibition against vacation rentals. They used a new term, other accommodations, to define vacation rentals. It's very similar to a previous term they had used, accommodations, but this is a new term, other accommodations, and other accommodations were prohibited by the ordinance. And put succinctly, this is a prohibition of vacation rentals. Therefore, it's preempted. It's from after 2011. Therefore, the exception does not apply. I want to address the exceptions. First by saying that it's not exceptions, it's exception. There's only one exception. And at the risk of being redundant, it's for a law or ordinance passed before June 1st, 2011. That's it. There is no exception based on intent. There's no exception based on a concept of continuing or carrying forward. There's no exception that you can have a new prohibition if you had a similar prohibition on the books already. Or you can pass a new prohibition if you have parallel prohibitions. Or even you can pass a prohibition if it's identical to a former prohibition. There are no such exceptions for these ideas of intent and parallel or other prohibitions. And there's certainly not one exception for an edict by footnote claiming an exception. We declare we have the right to do it, therefore it exists. And it just comes back to the simplicity of our argument, which is that there's a state preemption of vacation rental prohibitions, and that this does not meet the singular exception. Despite arguments about other exceptions, we believe they all fail because those exceptions don't exist. I want to briefly address two
So, Mr. Brady?
key- Yes, Your Honor.
Okay, so under the prior land development code, there was a restriction for short-term vacation rentals as would be applied to your clients. Is that correct?
No, Your Honor, there was not a prohibition on vacation rentals. There was a prohibition on accommodations, which were defined as a building type. Key to the definition was the term intended for. It was hotels, motels, bed and breakfasts, and more that were intended for transient rentals. So those building types were prohibited.
And those were only permitted in tourist districts, correct?
Yes, and
your clients' properties are not in tourist districts, correct?
Correct. They're in residential districts, and they were prohibited. Those building types were always prohibited in residential districts, but vacation rentals have always existed in residential districts.
Okay, and then we have the new land development code, correct?
Yes, Your Honor.
And the new land development code also prohibits your clients from using their properties for what's called this short-term rental, or that they're not permitted to be used for short-term rentals, similar, identical to the restriction that was put on them under the prior land development code, correct?
Respectfully, Your Honor, we don't think it's identical. We think it's confusingly close, but the prior prohibition was against a building type. Only a building type can be intended for. An activity can't be intended for. And the definition of accommodations is certain building types that are intended for something. Where the new prohibition changes in two key ways. Number one, it's no longer a prohibition on certain building types that were intended for certain prohibitions. The new prohibition affects all building types, including residential houses, which weren't built with the intention of being for short-term rentals. So they expanded it to include residential dwellings, because now it's not just a restriction on buildings that were intended for short-term rentals. Now it's all buildings. And the second change is that instead of just a restriction on transient rentals, it's now a restriction on all rentals up to 6 months. So they changed the restriction in two key fundamental ways.
Can you walk me through again where specifically the old LDC specifically allows short-term vacation rentals?
Yes, under the old LDC in Article 9, Section 2.1, there's a list of permitted uses. And both parties have cited to Article 9, Section 2.1. And it starts out in the standard building code manner, where it says that any use that's not explicitly permitted is prohibited. And then next, what it says is that accessory uses, contrary to being explicitly permitted or prohibited, are more or less explicitly are the opposite. They are, unless explicitly prohibited, they're permitted. And I'll quote the exact wording. It says accessory uses were, quote, permitted unless specifically provided otherwise. Permitted unless specifically provided otherwise. So rentals of all types qualify as an accessory use. So to clarify, and I'll give you the definition, we're a permitted use. Rentals of all types are a permitted use because they're an accessory use. And an accessory use is any use, and I'll quote, a use customarily incidental and subordinate to the principal use. So rentals are a use customarily incidental and subordinate to the principal use. So you won't see rentals listed as an explicitly permitted use in, I think, in anybody's building code. You'll see single family dwellings, duplexes, multifamily dwellings, and an emphasis on the building types because it is the building code. But then they say, hey, accessory uses, putting a tent in the backyard, renting out your house, they're all accessory uses and they are, quote, permitted unless specifically provided otherwise. So we believe that, and just historically, we all know that rentals are permitted. It's clearly an accessory use, and I that's for you to judge, but that's our position, is that very clearly it's an accessory use because it's incidental, etc. Number two, it's not explicitly prohibited elsewhere. And thirdly, because the rules of interpretation that we've cited to say if there's any doubt, it must be construed in our favor. Before I defer to Mr. Russell, I have just a few quick points. It took a team of attorneys and consultants 6 years, according to the city's wherefore clause in the ordinance. It took them 6 years to devise this ordinance. And so the parts where it's crafted to change the term accommodations to other accommodations, very confusing in my opinion. That was a part of a 6-year process. We believe that had they used the term vacation rentals, which is what it is, we wouldn't be here. Their whole case is built on the confusion of that term. That was part of the 6-year process. As was the footnote.
Why isn't the vacation rental the principal use?
Because the principal use of a single family, duplex, triplex, multifamily is long-term residency. That's the norm or the principal use.
And how is well, it's explain. I can maybe envision some. Explain to me in what situation a vacation rental would be an incidental use versus it's no longer incidental and it becomes the principal use. You agree that both could be true depending on the facts?
Yes, and I think I erred in what I said. I think actually the principal use that I would cite is a single family dwelling. That's the principal use, is the single family dwelling, reading from the chart. And then incidental to that would be any type of occupancy, whether it was owner occupied. Owner occupied is not a permitted use. Renting is not a permitted use. They're all incidental. Any type of occupancy is incidental.
Why?
Because the definition of incidental, accessory, it's an accessory use, not incidental use. Because the definition is satisfied. It's a use customarily incidental and subordinate to the principal use of a single family dwelling.
Well, I mean, if it's a subordinate use, then that sort of implies there has to be a principal use, correct? So in the circumstance of a vacation rental, what is the principal use?
Single family dwelling, quoting their list of principal uses.
So a single family would dwell in the vacation rental as the principal use. Is that what you're saying? It's
a building code, so they're speaking more of the use of the land. So the principal use of the land is to build a building. The incidental uses tend to be the activities that go on it. And if I may, Your Honor, I'd like to point out that we don't think this is relevant to our argument because no exception exists that says you can violate the state preemption because you have another prohibition on the books, even if you did.
Well, it goes to the issue of the prior prohibition, right? If there was one, correct?
Yes, it does, Your Honor. My point was limited to the point that we don't believe there was we don't believe that a prior prohibition is relevant.
So this whole discussion about the ancillary use and the principal use really is unnecessary for our consideration.
Before I yield to Mr. Russell, we believe that it's just in case Your Honors agreed that number one, they had a prior prohibition, which we don't believe they do, and number two, that an exception existed for that. To err on the extreme side of caution, we wanted to have this as a backup argument to our simple argument that they passed a prohibition after 2011 and you can't do that. And if I may, with Your Honor's permission, I'll yield to Mr. Russell.
Your Honor, I see that we're running closer into our rebuttal time. So I'll just briefly state that as Mr. Brady was just saying, the primary issue here is a matter of statutory interpretation. What does this state preemption statute say? Section 509.0327B is explicit. And so there's no question about resorting to other canons of statutory construction. It's just that the plain meaning of the statute should be enforced by this court. And I think that the lower court's order runs afoul of that. And I think that there's this confusion created about, well,
how much of that interpretation is predicated on the idea that the new land development code uses the word repealed as opposed to, say, amended?
Well, I think that is one key factor in determining whether or not whatever prior prohibition in the old land development code existed. The act of repealing it essentially voided out whatever law existed.
There are a couple of Supreme Court cases, one from as recently as a couple of years ago, that basically says when a statute, or in the case of this situation, an ordinance, is repealed and substantially reenacted, it's deemed to have been in operation from the original enactment. Does that body of law apply here?
I would not disagree that it does, but I don't believe that the new land development codes substantially reenacts what the old land development code said. And if the court's wondering whether or not the old land development code prohibited short-term rentals, our position is that it doesn't. And the reason we believe that it doesn't is because there's an ambiguity created by virtue of the fact that you have these short-term, you have these single-family residences that are explicitly permitted in residential zones. And there's the way that single-family residence is defined under the old land development code is that it's a building occupied and maintained exclusively as a residence for a single family. And so there's no durational component of that definition. And these are all explicitly permitted. Now, the city's position is...
So if I sign up for one of these places on VRBO or Airbnb, I'm allowed to bring my wife and, if I have them, my kids, but I'm not allowed to vacation with another couple because that would be two families?
Well, Your Honor, we're saying that under the specific facts of our case, our clients each filed affidavits confirming that they merely rented out their homes, their primary residences, to other families to use as their residence during their stay in Daytona Beach. There was never any factual dispute raised by the city on that point. And
David, you have about 2 minutes left.
And unless there's another question that the court would like me to address it in this immediate moment, I'd like to reserve the remainder of my time for rebuttal.
I guess I find that an interesting concept. So if, let's say we move into a hotel, I take the family on a vacation, and instead of staying in a vacation rental, we move into a hotel for 3 days. Is that my residence? is that the common and ordinary definition of the term residence?
Well, Your Honor, in one of the cases that we cite in relation to this proposition, we had it's a case out of the first DCA, the Santa Rosa case, where you're talking about a restrictive covenant that basically prohibits the operation of a business in this residential community. And people were renting out their homes as single family residences on a short-term basis. And there wasn't this clear prohibition against it. And so restrictive covenants in a deed are to be interpreted in the same manner as ordinances or statutes that would restrict the use of land. And for that reason, interpreting it in our client's favor, we feel that the court has to conclude that this is a residential use of their property, provided that they are, and I think it's undisputed here, renting out their homes for the purpose and use as a single family residence. And that's all that's occurred here. And there's been no disputed evidence.
I guess what I'm asking is, wouldn't it be the same if I rented a hotel room or a hotel suite for 3 days for my family and we went there for vacation? Why is that any different?
I believe it's different because a hotel has multiple rooms. This is a large business enterprise. Whereas, and I see that my time is.
As far as the term residence goes, why is it different? Would that be our residence for 3 days?
You could say that you resided there, but that doesn't make it a residence pursuant to the definition of the Land Development Code. You're still within a large facility that has multiple residences connected as one that's being rented out to multiple different families. And so it's different when you're talking about a single family residence that you're renting out to one family.
I guess my question goes to whether or not the family that's staying in the vacation rental for 3 days, whether that vacation rental is their residence for 3 days.
That is our position. Yes, that that a family staying in a single family residence, they're coming here. And
question to you was, does that, in your view, is that consistent with the ordinary meaning of the term residence? Do people, is that what somebody would say? Yes, this is my residence for 3 days on vacation. Would they call it their residence?
I believe that they are using it as their residence. Whether they called it that or not, I could not speak to that. But the question is whether that use is permitted of this facility. And I see that I've gone over my time, Your Honor. And unless you'd like me to try to address your question more explicitly, I'll yield to Mr. Glassman.
Mr. Glassman, you may proceed.
Thank you, Your Honor. May it please the court, Gary Glassman, Assistant City Attorney for the defendant in this case, the City of Daytona Beach. We are here on an appeal from a grant of summary judgment by the Circuit Court of the 7th Judicial Circuit. I believe the way that the plaintiff has framed this case is that there are basically two issues. The first one is, were short-term rentals permitted in residential zoning districts under what I call the prior Land Development Code? And the answer is, we say no. The second issue is, does what we call the new Land Development Code continue to prohibit short-term rentals in the single-family residential zoning district? And we say that it does. And I know I've said this in my brief, but I just want to be careful. By using terms prior and old or new, I'm not conceding in any way that the codes have changed or anything like that, or that the code is somehow subject to the statute that's now preempted local ordinances regarding short-term rentals. I think there's a key here that needs to be understood about zoning codes and land development codes. And we've discussed it a little bit. It appears in the brief and it appears in the motions. And that is when you interpret or not interpret, when you look at a code, a zoning code, you see the districts, single family, multifamily, whatever the district may be. And then what you do is you have a chart, and the chart tells you what is permitted. It doesn't tell you what's prohibited, because if they were to do that for every single zoning code designation, the code would be unwieldy, because there are so many uses that could be made of a property, it would be just unwieldy. So the code tells you what is permitted. And I think that that's important to understand because when you look at the prior land development code, what you see that the city specifically designated a tourist district for short-term rentals. They didn't put it in any other place. So I think that it's not even an inference. I think it's very clear that what the city was intending to do was to say, okay, you want short-term rentals, here's the only place that you can do it, in the tourist district. And I would cite to the record, Your Honor, it is, give me one quick second. Well, the section that I'm talking about is found on record page 176, where it says, this is how you define a code. It's defined by what is permitted, not what is prohibited. And if you look at the section dealing with the tourist development, which is record page 178, you will see that the tourist district T1 talks about accommodations. We know that the code defined accommodations as hotels, motels, tourist court, rooming house, or rental unit intended to be used by transient persons or tourists for overnight or short-term lodging. That's the only place in those tourist districts, that zoning district, that's the only place that you can have this type of use of the property, not in single-family residential properties. I understand that council has said, well, they've been doing it for years. Well, I'm sorry that they have. It's our opinion that then they have been violating our code. And that's probably why the Code Enforcement Department decided to look into these, because in fact, we were learning of the fact that there were violations that were being made of our land development code. So I think it's very clear. I don't think there's any question that the city had in the prior land development code the prohibition or the permission to only have short-term rentals in the tourist development district. To me, it's very clear. Now we go forward and say, okay, the state comes in 2011 and preempts the issue. But they provided for what I've called a grandfather clause. Grandfather clause essentially says, if you had an ordinance in effect prior to the preemption statute, that can continue to go forward. And in 2015, the city did, the word has been repealed, and I'll use that word because that does appear in the ordinance, but I don't think that that word repeal means anything in this particular case. It's just language. You can't have two codes at the same time, so naturally one has to go and the other has to come in. But by doing that, I don't think the city simply falls into the statute saying that they can't go ahead and continue to prohibit or to permit only having vacation rentals or tourist rentals in the tourist district. In any event, the city, after, as was mentioned by council, 6 years, please understand that in that 6 years, it was not just this issue that was being addressed by the city. The city created an entirely new land development code for all areas of the code, not just dealing with tourist development or rentals. So the fact that it took them quite a while to do is an enormous task. I can tell you that I don't have it in front of me, but our land development code runs at least 100, 200 pages. And this was an exacting work that was done by the city. So we come forward, and what's clearly there, Your Honor, is the fact that the city wanted to continue and did continue to have the tourist development district as the only place where you could have short-term rentals. They continued that. I don't think there was really any change. We talk about accommodation, other accommodations, they were essentially defined the same way. So we have this situation where the city is saying very clearly, we are going to continue to permit short-term rentals only in the tourist development district. And to be even clearer about it, they put in the footnote to the code, which says, this is exactly what we are doing. And I know there was a comment about, well, intent is not an exception. But I think when you're looking at a statute and you're trying to interpret it, and you're trying to interpret our code, I think the intent of the city was very clear. And what they were doing by putting in that particular footnote was saying, we are going to continue to permit rentals, tourist rentals, short-term rentals, only in the tourist district. And I don't think that the city has done anything else to indicate something otherwise. I think that the city has done exactly what it needed to do to comply with the preemption statute. We grandfathered in our prior prohibition or permission of only having short-term rentals in tourist districts. So I think that the circuit court made the right decision. The court reviewed the record and I think made the correct decision. So if there are questions, I'll be happy to answer them. But I think that in final, we would ask that this court, of course, affirm the decision of the circuit court.
Okay, there being no other questions from the panel, and the appellant has previously used all of their time. So at this point, we thank counsel for their arguments, and this court is adjourned. Thank you.
Thank you.
Your Honor.